My dear friend, most welcome to the channel. Our topic for today is Damnum Sine Injuria, which is one of the very important legal Latin doctrine of law of tort. Before moving ahead to understand it, please tell me one thing. If you have opened a public school at the roadside and you are doing a lot of good job, and that is how there are very good students and your school is running very good. What happens one day, opposite side seeing that your school is good, your another person open one public school and reduce the fees of his school 50% to your school. Now what happened? Most of the students, because of low fees, started taking admission there, and there is very less number of students in your school. Cutting all this scenario, you also try to reduce fees to the reasonable level, but the moment you reduce the fees, the opponent also reduce the fees, and that is how your school almost goes on the verge of closure. Now you tell me, in this situation, if you go to the court and making complaint of that opponent, what will be the judgment of the court? And this case is all about the this famous legal doctrine Damnum Sine Injuria. So please wait for some time. Your concept will be clear. However, you can conclude your judgment, and in the end, you can validate whether, as a owner of first public school, you will get injunction and compensation or not. We will be covering Damnum Sine Injuria under three following topics. First, we will understand meaning. We will also see the leading cases, because in examination point of view, writing legal cases is very important in law examination. And we'll also understand significance of this question. Please be continue till end of the video to have complete clarity on the concept of Damnum Sine Injuria. Meaning of legal doctrine. Meaning we can understand damnum literally means damage. We put comma here. Sine means without. Injuria means injury. You will be surprising what is the difference between damage and injury. Yes, there is a difference between law between damage and injury, and you will get clarity on that. Let us understand it more simply, that you got damage or loss due to someone, but it did not cause any legal injury to you. What is a legal injury? Legal injury means violation of legal right. There is no breach of any law. However, you got damage. This is the actual meaning of damnum sine injuria. In all situations where damage or loss has happened, but it is without any violation of legal right. In this situation, damnum sine injuria become applicable. Let us see with some cases now. Now we will have complete understanding. There are two cases from the Europe and two cases from the India. Because in examination they specifically ask, please give quote of the Indian leading cases. So we have covered Indian leading cases also. But first one is Gloucestershire Grammar High School. This is one of the most leading case of this doctrine Damnum Sine Injuria. And this is what we discussed in the beginning. Gloucestershire Grammar School was initially be established, running very well, but later on opponent opened similar school opposite side of the road and reduced fees, and because of all that, this school goes on the verge of closure. And when the matter reached to the court, the judgment was, since there is no any violation of legal right, there is no compensation or damages can be granted to the plaintiff, who was Gloucester Grammar High School. Please understand, you may be causing loss, but if there is no legal right violations, court cannot help you, because provision of damnum sine injuria. Another case is Mayor of Bradford versus Pickel. So this is also very interesting and very leading case. Mr. Mayor of Bradford and Pickles were never, they were having land adjacent to each others. And fact was that the Pickles land was at higher side of elevation, and mayor of Bradford lands is at the lower side. And because of rainwater, due to gravity, the water was coming from Pickel's land to mayor of Bradford. Until now, everything was normal. What happened? Mr. Pickel excavated one very deep well in his land. Since well was very deep, because as a result of this deep well, the water from underground water from the land of Mayor started percolating and flowing towards the Pickle well. And as a result, water table on the Mayor land become much down. And because of effect of that, Mayor approached the court. However, based upon the fact, since there was damage to mayor, but there was no legal injury or there was no violation of legal right, and that is how court denied any relief to mayor, and there was no compensation granted because of the provision of damnum sine injuria. I hope with two cases you get more clarity. Now let us have two more Indian cases which you can write in the exam as it is based upon your understanding. The third case is Srimati Ushaben versus Bhagya Laxmi Chitra Mandir. In around 1960 or 65, there was a movie Santoshi Mata. And this Santoshi Mata movie was being screened in Bhagya Laxmi Chitra Mandir, where Srimati Ushaben went and seen it. And she found that in this movie there was adverse remark made about Santoshi Mata, who was the goddess of Srimati Ushabe, and he got emotionally hurted, sentimentally hurted, and she complained in the court of law that this movie is against the sentiments of the Hindus and adverse thing has been said about Santoshi Mata, and that is why this movie should be stayed and there should be adverse legal action taken against the producer and Bhagya Lakshmi Chitra Mandir cinema. However, court find that there was no legal injury and there is no violation of any law in the movie, and that is how, though there was emotional hurt to Srimati Ushaben, but court denied the compensation, though damage was be there, but there was no legal injury. And the last one, which is again equally important, is town area committee versus Prabhudayal. The fact of the case is Prabhudayal has made certain soap in the market on the land which was unauthorized and belonging to town area municipal committee. The soap were on rented also. Prabhudayal was getting rent money also and enjoying ownership of the soap, though they were at unauthorized land. Town area committee municipal board demolished all the soaps, and because of this demolition, loss caused to Mr. Prabhudayal and he approached the court. However, now you can conclude what could have been happened. If you are saying that there was no compensation granted to Prabhudayal, as the soap were constructed on the unauthorized land and there was no legal right violation of Prabhudayal, then you are perfectly right and understand this concept very well. Since you have understand this concept, the significance, you can tell me, the significance is whatever loss someone may cause, until and unless there is no breach of the law, there cannot be compensation and there cannot be grant of any relief, as there is no cause of action to the individual. Merely loss or damage is not the ground for getting compensation. Let us summarize quickly. Meaning is, as you know now, loss without violation of legal right. And leading cases, we discussed the four leading cases: Gloucestershire, Mayor of Bradford, Srimati Ushaben, and Town Area Committee versus Prabhudayal. And significance also, you understand. What is significance? Yes, if there is laws and there is no violation of law, there is no remedy available for the same. I hope you understand the concept and this doctrine very well. All the best for your study. If you have any query, please write in comments box, and you can WhatsApp also on this number. If you like this video, please share to your friend, like, and keep connecting with our channel. Thank you very much.